Imagine ending an 18-year relationship, filing for a legal divorce, and having the court return your petition with a single devastating stamp: rejected, non-qualifying ceremony. This rejection means the court refuses to acknowledge that a marriage ever existed. Suddenly, the framework of family law designed to divide assets, to manage pensions, and award spousal maintenance all simply vanishes. In English family law, there are two distinct categories of defective marriages. The first is a void marriage. This is a severely flawed union. Perhaps one party simply lacked capacity, but the law still recognizes the attempt enough to grant a formal decree of nullity. This allows the vulnerable party to pursue financial remedies under the Matrimonial Causes Act 1973. The second category is a non-marriage, or a non-qualifying ceremony. Here, the formation is so legally deficient it falls entirely outside the scope of the act. The parties are treated merely as cohabitants, stripping them of all statutory family law protections. The difference between securing a fair financial settlement and walking away with nothing relies entirely on how the courts apply the strict statutory rules of formation to the ceremony in question. Every family law case must begin with a precise assessment of whether a legally recognized adult relationship was actually formed in the eyes of the state. To evaluate validity, practitioners use the bipartite test. A valid marriage needs two pillars: capacity and formalities. Capacity is essential validity, the inherent personal prerequisites an individual must meet to marry. Formalities are formal validity, the strict procedural steps demanded by the state. These two pillars operate independently, governed by distinct legislation, primarily the Matrimonial Causes Act 1973 for capacity and the Marriage Acts for formalities. Failing to properly satisfy either of these pillars causes the legal structure to collapse, pushing the union out of validity and into the complex, punitive territory of defective marriages. We begin with capacity. The rules governing who is allowed to marry are laid out in the Matrimonial Causes Act 1973, and for civil partnerships, the Civil Partnership Act 2004. The first constraint is domicile. A person's capacity to marry is governed by the law of their pre-marriage domicile. If you are domiciled in England and Wales, you must have capacity under English law, even if the ceremony occurs abroad. Next is the restriction against consanguinity. Closely related blood relatives, such as parents, children, or siblings, lack the legal capacity to marry each other based on genetic considerations. The law also restricts affinity, which prevents marriages between certain step relations to protect against potential exploitation within a family unit. Then there is the absolute prohibition on bigamy. Neither party can be currently married or in a civil partnership at the time of the new ceremony. Finally, capacity requires strict adherence to age limits. Under the Marriage and Civil Partnership Minimum Age Act 2022, the legal age for marriage is a hard floor of 18, eliminating the old exception that allowed 16 and 17-year-olds to marry with parental consent. If any of these essential conditions are breached, if a party is underage, closely related, or already married, they lack capacity from the outset. A ceremony can proceed flawlessly, but the marriage will be void. If capacity is met, we move to formal validity. The Marriage Acts of 1949 to 1994 dictate the specific procedural steps required to create a legally binding ceremony in England and Wales. Before a ceremony takes place, couples must complete civil preliminaries. This means giving formal notice of their intention to marry at a district registry office and waiting a mandatory 28 days. The only major exception to this civil notice is for Church of England weddings, which require their own specific preliminary procedure, known as the publication of banns in the parish church. When it comes to the ceremony itself, civil marriages face strict venue restrictions. They must occur in officially approved premises, a rigid geographical limitation. This is why Prince Charles and Camilla Parker Bowles married at the Windsor Guildhall rather than Windsor Castle, which lacked the required specific civil license. The ceremony must also be overseen by an authorized person, meaning a registrar or recognized religious official must be physically present to conduct or witness the vows. Following the vows, the parties, the witnesses, and the official must sign the official register to formally record the marriage with the state. Specific exemptions to these strict procedural rules exist in law, but they are narrow, applying primarily to Anglican, Quaker, and Jewish religious ceremonies. Currently, English law rigidly ties a marriage's formal validity directly to strict administrative compliance and the specific physical building where the ceremony takes place. When these formation rules are broken, family practitioners navigate a legal decision tree that splits defective ceremonies down two divergent legal paths: the void marriage and the non-marriage. The void pathway under Section 11 of the Matrimonial Causes Act captures breaches of capacity, or cases where parties willfully disregard certain formalities. Because the state recognizes the attempt at marriage, the vulnerable party retains the right to petition the court for financial orders. The non-marriage or non-qualifying ceremony pathway applies to events that are entirely alien to English law, ceremonies that fail to engage with the statutory requirements on almost every level, leaving parties with no statutory remedies. Consider the 2020 case of Akhtar v. Khan. A couple lived together for 18 years and raised 4 children after undergoing an Islamic nikah ceremony. Despite their genuine intent to marry, the nikah failed the formal validity test completely. No civil notice was given, no registrar was present, and the ceremony took place in an unapproved building. This principle was similarly enforced in Al-Gamal v. Al-Maktoum, where an alleged secret Islamic ceremony in a London flat lacked any written evidence or compliance with the Marriage Acts. In both cases, the court's rationale was identical. A ceremony so profoundly deficient in English legal formalities cannot be considered a void marriage. It is simply a non-qualifying ceremony. In a non-marriage, the court lacks the jurisdiction to grant a nullity order. The applicant is completely barred from claiming the property transfers or financial remedies they would otherwise be entitled to under a legal divorce. The current building-based system creates a dangerous legal landscape. Couples who genuinely believe they are formalizing their commitment regularly and unknowingly enter into non-qualifying ceremonies. The increasing secularization of society and the rise of diverse religious practices actively clash with the archaic structure of the Marriage Acts. Spouses often spend decades believing they share a valid legal status, only discovering the reality of their non-marriage when the relationship finally breaks down. This friction generates severe financial inequities, penalizing vulnerable parties who are left entirely without recourse after years of shared financial life. The law requires a systemic structural fix. Piecemeal exceptions to a 1949 statute are no longer sufficient to protect modern families from falling into technical procedural traps. To address this, the 2022 Law Commission report Celebrating Marriage offers a direct remedy. Its core proposal shifts the legal anchor of marriage away from the physical venue, placing it instead squarely on an authorized officiant. By regulating the person rather than the place, this reform allows for the legal recognition of outdoor weddings and ceremonies held in non-approved premises. It also extends formal legal recognition to secular and humanist weddings, removing the barrier of the old religious-only exemptions. Furthermore, the Commission outlines a simplified, universal legal preliminary notice system, applying evenly to all couples, regardless of how or where they choose to celebrate. Until these reforms are enacted, thoroughly understanding the current statutory requirements for capacity and formalities remains essential. It is the only way to accurately determine validity, avoid the harsh consequences of a non-marriage, and properly advise clients navigating the dissolution of adult relationships.